Supreme Court Justice Amy Coney Barrett has refused to block a plan by Indiana University to require students and employees to get vaccinated against the coronavirus to attend classes or keep their job. Brigida Santos joins me now to talk about the details. Brigida, first off, break down Justice Barrett's decision for us, if you would.
Associate Justice Barrett handles emergency cases for the U.S. Court of Appeals 7th Circuit, which includes Indiana. Now, she acted on her own in rejecting a plea from 8 students seeking exemption from Indiana University's COVID vaccine mandate. The students claimed they have a constitutional right to bodily autonomy and of medical treatment choice. Justice Barrett did not offer an explanation for her decision not to refer the case to the full 9-justice court, but throughout history, state Supreme Courts and lower federal courts have consistently upheld vaccination mandates as a condition of school attendance or job employment. So far, the U.S. Supreme Court has declined to interfere with those decisions, as we've just seen again here in the case of Indiana University.
Yeah, I don't think there's any earth-shattering qualities about this opinion. She's just relied on a lot of precedent for making this kind of decision. Vaccine mandates aren't new. Where have they been implemented? Time after time, we've seen them implemented. And there's some suggestion that she did something untoward here. No, she didn't. She followed the precedent that's been out there a long time. What's your take?
Absolutely. Today, all U.S. states and territories have vaccination requirements for children to attend schools and child care facilities. Most schools require vaccines for things like measles, polio, chickenpox, meningitis, and whooping cough. And these requirements are legal. Nearly 100 years ago, the Supreme Court issued a landmark ruling in Jacobson versus Massachusetts, upholding the right of states to compel vaccination as a reasonable exercise of police power to ensure public health. Back then, the court rejected the idea of a personal choice exemption, ruling that vaccine mandates do not violate the 14th Amendment because the Constitution doesn't give every person the absolute right to be wholly free from restraint at all times, especially when it comes to the safety of society.
Now, you got that right on the head. I mean, it was just a perfect analysis of what the law, how it's developed, and where we are today. What did the court say about religious exemptions from vaccination requirements?
The U.S. Supreme Court has yet to directly address whether a person has a constitutional right to refuse vaccination on religious grounds, but rulings in other SCOTUS cases provide clues as to how it could rule in the future if it chooses to finally hear a relevant case. For example, in 1944, SCOTUS heard a case involving child labor under an asserted right of religious freedom. The court ruled that neither the rights of religion or parenthood are beyond limitation, and that the state can restrict parents' control by prohibiting child labor, requiring school attendance, and other things. It gave the example that a parent cannot claim freedom from compulsory vaccination for a child on religious grounds because the right to practice religion freely does not include liberty to expose the community or a child to communicable disease, ill health, or death. That being said, today 48 states do allow religious exemptions by statute, and the courts are mixed over whether states can actually do so.
Brigida, as I listen to you, it's as if you were in constitutional law classes with me. That was a perfect evaluation of where we are on vaccinations. Very nice recap there. Very nice job. Thank you for joining me, okay?
Anytime, Mike.